Again, welcome to Mid-South MGMA, our, I'll say, second COVID-induced teleconference, meeting via Zoom. Definitely missing some good fried chicken at Chickasaw today, or other good salad. I'll say maybe good salad. So hopefully we'll be able to get back to normal here in the months ahead, but definitely excited to be meeting together and sharing information as we figure things out. A couple announcements or things to remind everybody. The state is still on go for the fall conference here in Memphis at the guest house. We have not, I'll say, received any notice or information that anticipates it to, I'll say, be canceled. But again, things can change, obviously, depending on what the county and the city allows if things get worse before they get better. So it is slated for September the 17th. That's a Thursday and Friday in September, again at the guest house. Our next Mid-South MGMA teleconference meeting will be July the 16th. We're excited to have some representation from our friends over at SBMIC, speaking directly to practice management and everyone related in the medical field, obviously, in dealing with these phases of COVID, the impact, the next steps, and how we can all get through this together. So we're excited to have the next meeting as well. But today we have Emma Davis, and Adriana, I'll let you go ahead and introduce our speaker.
Absolutely. Well, welcome everyone. Thank you for joining us. And we just want to welcome back Emma Davis. She has spoken with us before, and we're happy to have her again to speak on a very meaningful topic around issues in our workplace, especially as we are seeing marijuana become legalized in states. So just a little bit about Emma. She works at Baker Donelson, and she represents companies before the state and federal courts around EEOC issues in the Department of Labor. She helps defend them against allegations of discrimination, harassment, retaliation, wage and hour violations, and other claims. Ms. Davis also helps advise companies as to issues related to employee disability and medical leave, termination of employment, and employee discipline, and company policies and procedures, including revisions to employer handbooks and other required employee documentation. So she is very much invested in how employers present themselves, how they work with HR departments, and all issues related to the workplace and employees. So without further ado, we welcome Ms. Emma Davis to take it over. Thank you.
Thank you so much. Thank you everyone for joining me today remotely. So as Adriana said, I'm going to be talking about two kind of major employment laws that we see in the workplace a lot, and that is quite honestly a bit of a struggle for a lot of HR professionals to apply. This is the Americans with Disabilities Act and the Family and Medical Leave Act. And so what I'm going to do today is kind of go over the requirements for each of those laws, and then we'll work through some examples based upon things that we've seen come into play in the workplace that present a lot of gray areas. And I hope that through these examples, you'll have some resources and be able to gain some practical knowledge about how these laws work. So we'll talk about migraines, which are something that can be considered a disability. We'll talk about dementia, which is also something that can be considered a disability, and that is quite frankly difficult to deal with in the workplace, especially in some of the professional scenarios such as lawyers and doctors. And then we'll kind of switch gears and talk about a kind of related issue, which is the legalization of marijuana and how that impacts the workplace now, specifically with employees that are requesting accommodations for medicinal use of marijuana, and if you have drug testing policies, how the legalization of marijuana in different jurisdictions may affect your ability to test employees for the presence of that drug. And I will try to save some time for questions at the end, and we'll go ahead and get started. So we'll first talk about the Family and Medical Leave Act. So this is applicable when an employee requests an accommodation, and I'll describe what an accommodation is, but it's basically asking you as the employer if they can take time off or if they can have some sort of adjustment to their workplace to make it easier for them to do their job based upon a medical reason. So the first law is the Family and Medical Leave Act. This entitles eligible employees of covered employers to take up to 12 weeks of unpaid job protected leave. This is only for specified family and medical reasons and within a 1-year period. So they get 12 weeks of unpaid leave within a 1-year period. And as you'll see, not every employee, not every employer is entitled to this. So a covered employer is private employers with 50 or more employees, and it also covers state and local government employers without regard to the number of employees employed. So you have to have a certain number of employees, and actually counting the number of employees, if you're kind of on the line, gets really, really tricky. So I would definitely suggest getting some advice if you're not sure.
Hey, Emma, we're not seeing your slides advance, so I just wanted to give you a quick note on that.
Let's see. How about now? Can you see it?
We can see the screen. It just doesn't look like the slides are advancing. We see the presentation view where your title slide is there, and then we see the first slide off to the right.
All right, let's see. What about now?
Yeah, it's not advancing, but it's still, we see the screen. It's just not advancing. Should be able to go to wherever your normal, the way you view PowerPoint and advance it.
Yeah. Let's see. Sorry about that.
That's okay.
Let me try to, I'm going to try to reopen it.
Okay.
Okay. How about now? Can you see now?
Yeah, we can see the screen.
All right. Let's see if I can move through. Okay, can you see the next slide?
Yes.
Okay, awesome. Sorry about that.
That's okay.
Thank you for telling me. Okay, so as I was saying, so only certain employers are covered. So if you have a few number of employees, make sure that you're actually covered, and the calculation of the number of employees is really technical. If you are a covered employer, the employee also has to be eligible. So they have to have worked for you for at least 12 months and for 1,250 hours prior to the start of the leave. So they don't get to start their job and automatically get FMLA leave. They also have to be employed at a work site with 50 employees within a 75-mile radius. And this goes to the covered employer calculation. As I was saying, it gets really technical. You're looking at geographic scope. You're looking at how many hours the employees work. So if you're on the line, definitely get some legal advice. But the FMLA, in contrast to the ADA, which I'll talk about next, is pretty technical. So the reasons that an employee can take FMLA leave are listed here. So it's the birth of a child or to care for a newborn, the placement of a child with the employee for adoption or foster care, to care for the employee's spouse, child, or parent with a serious health condition. And the most frequent one that we see is the employee's own serious health condition. The serious health condition is a defined term, so you'll want to make sure that something actually consists of a serious health condition before giving them FMLA leave. And usually that will come down to, does their healthcare provider say that it's a serious health condition? And any qualifying exigency arising out of the fact that the employee's spouse, son, daughter, or parent is a covered military member on covered active duty. So there's a military leave component to it as well. Okay, so the next law is the one that is mostly going to be in play with the stuff that I'm talking about today. That is the Americans with Disabilities Act. And what it says is that employers must reasonably accommodate qualified individuals with a disability if the employer can do so without an undue hardship. Okay, that's a mouthful of words, and I've bolded the words that are defined terms. So what's a reasonable accommodation? What's a qualified individual? What's a disability, and what is an undue hardship? So the first definition, reasonable accommodation, is any change in the work environment or in the way things are customarily done that enables an individual with a disability to enjoy equal employment opportunities. So when we talk about migraines and dementia, I'll give you some examples of what are considered reasonable accommodations. Unlike the FMLA, the ADA is really based on circumstance, and a lot of times you can't 100% predict if a court's going to agree that an accommodation is reasonable or not reasonable. So you really have to understand the aim of the law and be able to justify what decisions you're making to be able to defend that later if you need to in litigation. So you don't have to provide an accommodation if it poses an undue hardship to you as an employer. And I will say that the undue hardship inquiry is really, really hard to prove, especially if you're a larger employee and you're, have a lot of money. Frankly, courts are really going to say, okay, you could have done this accommodation. This is nothing compared to, your overhead or any of that. So I would say we try to shy away from the undue hardship thing, but it does come into play sometimes in litigation. But I say that to say, don't automatically assume something's going to be an undue hardship, because courts kind of scrutinize that pretty heavily. So often employees requesting an accommodation will fall under both statutes. And that means, say, for example, an employee has a serious medical condition that could also be considered a disability. So maybe they want some leave. Well, that would be covered by the FMLA likely, and it could be unpaid leave for 12 weeks. But if they can't come back to work after the 12 weeks are up and they still have this disability that's preventing them from coming to work, but maybe they need just one more week off, that one additional week could be covered by the ADA. That additional week off could be considered a reasonable accommodation. So the tricky part is both laws apply in a lot of scenarios, and you have to kind of parse out which one comes into play. So we'll kind of work through some of that as well. So the biggest tool that I can provide you today, I think, is this interactive process checklist. So the interactive process is a term that is used under the ADA, and it's basically what you're required to do as an employer, if your employee is asking for a reasonable accommodation for a disability. So first you'll ask, has the employee requested an accommodation? A lot of times an employee will not think of an accommodation that they need. They'll come to you and say, I'm having a lot of trouble getting to work by 9 a.m. Maybe they have migraines that kind of go away by 10 a.m. I don't know if that exists, but it's something where the employee is having a medical issue and they're not really sure what to do, but they need to kind of change their work environment. Well, that could be considered a request for an accommodation. So as soon as you're kind of aware that the employee might need some help, that's kind of when your responsibilities under the ADA and possibly the FMLA are triggered. Has the employee supplied you with any doctor's notes, FMLA certification, return to work notes, or other medical documentation regarding work restrictions or a need for leave? So this is a tool where you'll want to get some healthcare provider medical opinion to back up what your employee is saying. And there's a way to do that, and I'll show you an example of a letter that we often will send to an employee's healthcare provider. So say, for example, they've reported to you that they suffer from migraines and they need every Monday off. Okay, well, you need some justification for that. So you'll want to get a healthcare provider to weigh in and make sure that that's a legitimate request, and you're allowed to do that as an employer. Have you determined if the employee has an ADA covered disability? How do you do this? So the ADA these days, basically anything can be considered a disability. It has to substantially limit a major life activity, which is, again, a mouthful of words, but it's basically a condition that affects the employee's day-to-day life. And it's really hard to argue that something isn't a disability, and there are certainly things that come up that are not disabilities, but like the undue hardship inquiry, I wouldn't start with, well, that's not a disability. I would start with, okay, well, let's get some medical documentation. Let's kind of explore what's going on with you. And I would err on the side of thinking this could possibly be a disability, especially if the thing that they're asking for is not burdensome to provide. Okay, so the next thing, you'll want to ask their healthcare provider for input regarding restrictions and accommodations. So this fitness for duty letter that's referenced there, I'll show you an example of this. We send these out a lot when an employee is asking for a certain accommodation. We want the doctor to weigh in and say, that's legitimate. Maybe they don't need to come in until 10 a.m. and the doctor says, yeah, by 10 a.m. they're fine. So if you could just let them, make their work day a little bit different in terms of the hours that they need to be at work, that would get them there. so the doctor can actually weigh in on the reasonable accommodation. Have you asked input from management about accommodation? So talk to their supervisor. If you're an HR professional and you're not sure kind of what their job requires, get input from their supervisor. This website that I have listed is askjan.org. Excuse me. It's a great website. It's put on by the government, and it is a great resource for ADA questions. So if you're ever confused and you're trying to Google something, go to this website as kind of one of your first resources. Obviously, I would recommend getting legal advice, but look at askjan.org because they might have some scenarios that will be helpful to you. Make sure that you document all of your conversations and communications. Even if they're oral communications, like an employee comes into your office and says, my doctor just told me that I can't work on Mondays, and you have a conversation with them about it, make a note, the time, where the conversation took place, what the employee said, and what you said in response. This will be critical to proving that you engaged in this required interactive process. And this is like our Exhibit A when we're in litigation, we're saying, well, this employee didn't actually ask for this accommodation. We have this documented in this conversation, and they didn't say that. Okay, so this is a sample fitness for duty letter. This is what we usually send out to healthcare providers when an employee presents you with a request for an accommodation, or they say that they have a medical condition and they can't do a certain aspect of their job in the way that they're required. So you'll address it to the healthcare provider. You can kind of provide the context of what's going on. So you can say, you know, this employee has been coming in late. He or she has been exhibiting odd behavior. She's forgetting things. Just kind of describe what's going on with the employee that's presenting a problem. Or if you haven't actually observed it, describe what the employee has reported to you. This employee says, I have migraines and I can't come to work until 10 a.m. Put that in the letter so they understand what the scenario is and what you're asking them to weigh in on. So some examples, they might have been off work and returned with a doctor's note that didn't really have information in there about what was going on. They're requesting more time off, but it's really unclear whether they still have this medical condition that they're saying. So you can get clarification from the doctor if they've been absent or if you've noticed a change in behavior. And we'll talk about that with the dementia issue that comes up sometimes. So then in that last paragraph, you'll say, we need additional information from you to determine if this employee is able to perform, and you got to put this language in there, the essential functions of his or her position with or without reasonable accommodations in a manner that would not create an unsafe working environment for him or herself or others. So this is the ADA's language. It's basically, what are the essential functions of this job? Well, if they can perform all of the essential functions of their job still, is it really an issue? I mean, what the ADA is really concerned with are accommodations that kind of change these essential functions of the job. And this is a point where I would encourage you to make sure you're always reviewing your job descriptions, because we like to attach those and say, we had to fire this employee because this was an essential function of his job that he could no longer perform. There was no reasonable accommodation that we could provide. And because he couldn't perform this essential function, we had to terminate his employment. So it's kind of technical language, but it's just what's important about this job and can they perform it? If not, this is when we need to figure out if there's an accommodation. So you'll list the essential functions of the position, and we'll want to attach the job description. You can list additional requirements, like sometimes we'll attach the job description, but it doesn't indicate maybe this employee works outside in the cold or outside in the heat, and that's kind of something that is coming into play with whatever their condition is. So you can add stuff in there, but you don't want to look like you're manufacturing some condition of their job that didn't exist so you can just get them out of there. So it has to be legitimate, obviously, but not everything is going to be included in the job description. This last paragraph is kind of a disclaimer. It's basically, so the Genetic Information Non-Discrimination Act basically says that you can't request genetic information about your employees. And so you're basically saying, we don't want all of this background stuff about, you know, the family medical history and all of that. So you're basically saying, doctor, just focus on what I'm asking you. Don't give me their entire medical file because you don't want to unnecessarily have access to that. So we put that in there. And then we end the letter with specific questions, and these are kind of the same questions that we put in all of these letters, and it really narrows the focus to that ADA language. So you ask, you know, can they perform the essential functions without posing a threat? You know, say that an essential function of the job is them climbing up on a high ladder. Well, if they have, you know, epilepsy or some condition that might cause them to fall off of it, well, they can't do that most likely, and that would pose a threat to him or herself. You'll ask the doctor to explain with specificity what they're not able to do. How does their condition limit their ability to perform the essential functions? You want to tie their medical condition to what they're saying that they can no longer do. You'll ask for the duration of the condition. So this comes into play a lot when we see like employees on medical leave and they need to extend it, and it's kind of unclear like when they're coming back to work and when their follow-up appointment is. And so you'll want to really narrow down, okay, well, if you're not sure how long this condition is going to last, well, when's the next time that you're going to evaluate them? And then you'll ask the doctor to identify some accommodations that the doctor can think of. And then you'll ask the doctor, is there any accommodation that you can think of that would allow them to do their job? And then again, ask for the anticipated duration of their condition. We usually give them 2 weeks to respond. That's a lot of time when an employee is out and you're paying or not paying them, but holding their job position open. You can either give this letter to the employee to take to their healthcare provider, or if you know the employee's healthcare provider, and I would keep the employee in the loop during all of this. If you know their healthcare provider, you can send it to them, and the employee should be aware that you're doing that. Okay, so this is kind of what we were talking about, the interactive process, do the dance. So you want to do this back and forth with your employee. Excuse me, this is actually language from a Fifth Circuit case, but it says that the employer and employee have to engage in this flexible interactive process. They want to see a back and forth about discussing, okay, well, what's this health condition? Did you consider reasonable accommodations? If you did, what did and didn't work? And that's where documentation is really key to prove that you engaged in this process. So failure to engage in the process is a violation of the ADA if you don't do it at all, or if you did so without a genuine effort to explore whether reasonable accommodations were available. And again, this is where documentation is really your friend. So both you and your employee have to participate in this interactive process. And we see this a lot when employees kind of fail to respond to questions. So if an employee is out for a number of days and you're calling them and emailing them and sending them letters saying what's going on, update me on your medical condition, you said you were only going to be out till Friday, well, it's now Wednesday of the next week, and the employee just doesn't respond, continue to try to reach out to them, document all of that, and if they don't respond in a reasonable way, the employee failed to engage in the interactive process. And so they don't have a right under the ADA to come after you and say that you didn't reasonably accommodate them. Okay, so we'll kind of go to the managing migraine accommodation request. So these little bubbles are examples of different accommodations that you can provide. And some of these are really kind of something the employee could do, but it's something that you could also help provide them. So if they don't have access to food and they need an extra 15 minutes break, we see this a lot with people with diabetes. They need extra breaks to have a snack or, you know, kind of take a break to check their blood pressure. So some of this stuff is really easy, and it's an accommodation that is really not going to be an undue hardship. You can suggest that they get a fan at their desk. We'll talk about this a little bit later, but I know like scented perfumes and candles are often a trigger for migraines. So that's something that you can institute a policy in your workplace where you say, you know, no perfumes or no like diffusers in your office, those kind of things. Okay, so this is migraine Maggie protected under the ADA? So we'll kind of get into when someone isn't really seeming like they are suffering from migraines in the way that they're saying they are. You might want some more information, but just generally, not all migraines are classified as a disability. So like I said, under the ADA, something can be considered a disability if it substantially limits one or more major life activities. And so these are defined terms, but it's basically, is it limiting your everyday life? Is it prohibiting you from enjoying, you know, getting out of bed, you know, running errands, doing the daily activities that a person would normally do? Does it affect them more frequently than once a year? Employees can seek time off for migraines under the FMLA if they qualify as a serious health condition. So this is exactly where you would want to engage in that interactive process. Send a fitness for duty letter to the healthcare provider and get information. Do they take medication for migraines? Have they ever been tested for it? Have they ever seen you for it? How often have they reported that they have migraines? So this is where you can really dig in and get legitimate medical information about what's going on. Again, this is a list of some accommodations that you can provide. You know, some of these things are maybe harder than others, like filters to fluorescent lights and all of that. But, you know, if they have an office, maybe they could turn their office light off. Asking employees to voluntarily refrain from wearing fragrances. So this is an example of, like, you know, these are things that you could work with your employee and say, you know, would it help if we ask people to stop wearing perfume to work? That's a reasonable accommodation. And if that gets you there, I mean, that's low cost to you to comply with the ADA. Okay, so if you think that this person is kind of lying or stretching the truth, you will want to get that medical opinion and make sure that this is legitimate. So under the FMLA, you can get authentication of like a medical note or clarification if the medical note is not clear. So if you get a note from a healthcare provider and you're not sure that it's legitimate, you can verify that that doctor's office sent that note. I mean, I've actually had a scenario where someone sent in a doctor's note and we weren't really sure if it was a legit doctor's note. So you can call and find out. Or you can clarify, say the doctor's note is not specific about the duration or the frequency of the migraines, or it's not really clear what accommodation they might need. You can clarify what's in there. I would suggest not having the supervisor of the employee contacting the healthcare provider. I would put that with HR. Again, it just kind of separates you from having claims of retaliation or discrimination. You kind of want to separate the levels of that. Also, I would really stick to making sure that you're not just having a conversation with the doctor, because again, you want to limit the amount of information that you're getting to what is directly related to the disability. And we can help draft, and there's sample letters out there, you know, asking for authentication or clarification. So that's a good way to document it and limit the scope of what you're asking for. So this is a concept under the FMLA. It's recertification. So if an employee has an ongoing medical condition and say that they've, you know, reported that they need intermittent time off under the FMLA for 6 months, every, you know, couple of weeks they take a few days off. Well, you're not really sure if they're still having that medical condition, and maybe the doctor said this is only going to last a month. Well, you can request that the doctor weigh in and say what's going on now. So under the FMLA, you can require the employee to recertify their medical condition no more than every 30 days, so basically once a month, and only in connection with an employee's absence. If the certification indicates that the maximum duration of the health condition is more than 30 days, you need to wait more than 30 days. Wait until, like, say the doctor says, this condition is going to last for 45 days. Well, don't go after 30 days and say, is it still going to last 15 more days? You got to wait until the duration that was previously provided. In any case, though, every 6 months you can ask for that recertification. And this is a prime example of how technical the FMLA is. And, you know, I would just make sure if someone is on FMLA leave, at each step, consult with the FMLA, consult with your attorney, and just make sure that you're sending the right letters, doing it at the right time, because it gets a little technical. You can request recertification in less than 30 days if the employee requests an extension of leave. So say they originally only wanted 15 days off and then they want 5 more days, you can request recertification at that point. If the circumstances have changed, so they were out for migraines, but now they need to be out for a broken ankle. Well, that's a totally different scenario, so you can ask for more information on the new condition. Or if you receive information that causes you to doubt the reason for their absence or the continuing validity of the certification. This is kind of tricky. You want to make sure that you can kind of document and defend what about the employee's behavior is causing you to think that they might be lying. You know, sometimes it can be them posting on Facebook that they're at the beach, but they weren't supposed to be out in the sun. I mean, it's different stuff like that, but you'll want to make sure that you think that through before you go back and talk to the doctor. You can get second or third opinions on the need for leave. Again, this is one of those things that there's kind of a cost shifting procedure in here where as the employer, eventually you're going to have to pay for the doctor bill if you're asking them to get a second and third opinion. So it's kind of one of those last resort things, but if you're thinking about doing it, make sure that you consult with someone who knows what they're doing under this part. Okay. So if you're starting to have some doubts, look for inconsistent or suspicious behavior. So if the person that has migraines is always absent on Fridays and Mondays, well, it just looks like they want to have a long weekend. So you might want to talk to their doctor, send them that letter and say, why, you know, this employee is absent every single Monday. I mean, that's going to tell the doctor what's going on, and the doctor can weigh in on whether that's legitimate. Facebook posting, that's a big thing. You know, I wouldn't necessarily try to go friend all your employees just to spy on them, but if you're friends with an employee and you see something that's kind of wrong or that's inconsistent with what they're saying, that would definitely be something you'd want to document and discuss with them. If their absences are inconsistent with the medical certification and they're trying to fold all of their absences under this umbrella of the condition, that's another scenario where you can kind of get further clarification. So I would suggest kind of being open with your employee. Don't do surveillance or use a private investigator without consulting with an attorney, because you can get into some trouble with that. But make sure that you're documenting and trying to figure out what's going on with the employee. And if you really suspect that the employee is pulling a fast one on you and you want to do surveillance, make sure to talk to an attorney before you do that. Okay, so now we'll kind of switch gears to dementia, which is another really tricky issue in the workplace that falls under both the ADA and the FMLA. We're seeing as the working population is aging and people are retiring later, people developing dementia and being still in their jobs. And kind of like I mentioned, this comes to be a problem in a lot of professions where, like, you know, for example, in my profession, if a lawyer is giving incorrect legal advice, I mean, that can have pretty serious consequences, or if it's a doctor making mistakes or misdiagnosing, I mean, that can be pretty serious. So it's definitely something that you want to be able to deal with if you suspect that that's going on with someone. Here are some examples of how dementia might play out in the workplace. So a manufacturing employee forgets to run through safety protocols. I mean, that's bad. A lawyer giving incorrect or outdated legal advice. An employee exhibiting forgetfulness or repetitiveness. So like kind of a change in behavior that you're kind of like, oh, maybe something's going on with them. A nurse forgetting to check for drug allergies prior to dispensing medication, or an administrative assistant not being able to do routine tasks that they have always been able to do. So here are some more signs of dementia. So deterioration. So noticing a kind of a change in behavior, you know, a lawyer that was always on top of it, always knew the latest trends, was able to advise clients and always be right, is somehow still stuck, you know, in the past and not really understanding that things are changing, repeating themselves, not really understanding what's going on. Not remembering appointments or deadlines, not aware of mistakes that they're being made, or loss of concentration, kind of being disoriented or lost, avoiding responsibility or having a difficulty in communication. So as you can see, this is gray and it's hard, but I think the biggest key is maybe noticing a change in behavior from what was going on before. So again, you'll want to engage in the interactive process. So with this one, this is hard because, I mean, I think having a conversation with because like someone with dementia is not going to come to you necessarily and say, I'm forgetting a lot of stuff. Like, it's usually they're not really aware of what's going on. So it's kind of up to you to kind of initiate the conversation. So you'll probably want to approach them and give them specific examples so it doesn't look like you're just unhappy with them or you don't like them, but you know, maybe they did a presentation and totally lost their train of thought, or were saying just totally wrong things. missing meetings, missing deadlines. So it's concrete things that are actually causing you concern. And so that's really what I would focus on. And again, documentation is really important here. So you'll tell them, you know, this is not like you, and express concern about that. So like I said, keep thorough records of changes in behaviors. So make sure to document, you know, this presentation occurred on this date. This client was there and they said the totally wrong thing, or this doctor saw this patient and misdiagnosed what was going on. I mean, obviously that would have much larger consequences in the medical field, but you'll make sure to document everything so you can go back and say, you know, on this date you made this mistake. So it's not just kind of a vague, you're not yourself. You'll want to send a fitness for duty letter most likely. You'll want to get some information from a healthcare provider, so it's not just based on kind of your assumptions about what's going on with the employee, but actually have them evaluated. And, you know, a lot of times this happens to someone later in life. Maybe they're thinking about retiring, and so you can be able to answer questions about early retirement or disability, or, you know, what kind of options they might have if they're ready to kind of end working for you. Okay, so some reasonable accommodations. So this is an interactive process. You want to ask the employee, what can we do? What do you think would be helpful for you? So it could be a change in schedule. It could be having calendar reminders, restructuring job duties in a way that doesn't affect the essential functions of their job. So like, you're not going to restructure a doctor's job duties to where they're not seeing patients anymore. But I mean, maybe there's a way that you can kind of work around it to where they have some type of check on them. I don't know. I find that probably a little bit difficult to do. Maybe medications would be helpful, doing a flexible schedule, written instructions, maybe someone checking in on them. You know, a lot of this seems like probably not going to really help, but you'll want to engage in the interactive process before you just say, you're done working here, you have dementia, you can't do this anymore. You'll want to kind of explore what you can do. So if there is no reasonable accommodation, and kind of like I hinted, you might have a difficulty finding a reasonable accommodation for someone with dementia if it's actually legitimate. And a lot of times, you know, the healthcare provider will confirm that for you. So you'll want to consider maybe a severance package, long or short-term disability, or offering assistance in Social Security disability benefits. So kind of a downer, but it happens in the workplace, and I think it's better to be prepared for that conversation and for kind of what's going on with those employees, because we're seeing a lot more of that probably than we did in the past. Okay, I'm going to totally switch gears now and talk about weed in the workplace. So the legalization of marijuana. This was a hot topic, you know, a year ago, 2 years ago, when states really started to enact laws legalizing the use of marijuana, both medicinally and recreationally. And a lot of employers, especially multi-state employers, were like, you know, this policy is wrong for this, you know, the state of California. But we also have employees in Tennessee where marijuana is still illegal. What are we supposed to do? So I'll kind of walk you through how this plays out. So right now for recreational marijuana, it's legal in 11 states in the District of Columbia. Medical marijuana is legal in 21 additional states. Some states have decriminalized possession of marijuana, which means it's not legal, but it's not a criminal offense if you're in possession of it. In Tennessee, it's a little bit easier. Possession and use of marijuana are currently illegal here, both recreationally and medically. So here's a helpful map. As you can see, the recreational marijuana states are kind of not close to Tennessee, but the medical marijuana states border Tennessee. And so like Arkansas, for example, if you have people in West Memphis, Arkansas, who have been prescribed medical marijuana by their healthcare provider, I mean, that's pretty close to home, and that's something that you're going to have to deal with as their employer. All right, so obviously you guys can't answer a poll question, but think about the answer in your head. So in Tennessee, can I drug test employees for marijuana and terminate them if they test positive? So not a shocker, yes. So in Tennessee, the use of marijuana is not legal, so you are allowed to test employees for it and fire them or not hire them if they test positive for it. pay attention to the law in our state. There was a bill introduced in 2019 for medical marijuana to be established as a legal program in Tennessee. The bill ultimately was abandoned, but we think maybe the trend is heading towards that way. So just make sure that you're up to date on current laws, and I'm sure as soon as Tennessee passes a law, you'll probably hear about it. Always note marijuana is still illegal under federal law, so that's pretty tricky when it comes to you as an employer figuring out what you want to do. But I will say that there's some helpful policies for states where marijuana is legal, so I'll kind of go through some of that. All right, so should you test for marijuana use in employment-related drug testing? Okay, so this is kind of something that just kind of depends on the nature of your business. What we're seeing, like even in Tennessee, if you're, a Tennessee company and you have offices in Nevada and California and Maine, places where marijuana is legal, either recreationally and or medicinally, maybe you decide just for ease of application and for ease of your policies that you're just going to have like a policy where you're not going to fire someone who tests positive for marijuana, like on their pre-employment test or anything like that. So some places are doing that. So Caesars Entertainment, they're no longer testing applicants for marijuana. They just found it was counterproductive. And one of the reasons is, I think probably for them and some other employers, is that, it could disqualify applicants for marijuana use where it's an unnecessary barrier to finding good employees. So like if you don't have safety sensitive positions where that might be an issue, maybe you consider, okay, maybe we're not going to drug test our employees for this. It's just easier, especially since we have employees in these states where it's legal. You could only test for marijuana in safety sensitive positions, like I said. Or like this last point, do not test for marijuana in any state for the ease of having a company-wide consistent policy. So if you have California and Tennessee employees, you could just go to California law and say, we're not even going to go there. We're not going to try to fire employees who test positive for marijuana because it's just easier to apply. Apple has stopped testing most applicants for marijuana use, but they still test for safety-sensitive positions. So there's a lot of options in terms of your policies. It just kind of requires, figuring out what your needs are. Okay, must I accommodate my employees' use of medical marijuana? So this kind of ties back to the ADA and FMLA issues that we were talking about. Say the employee requests an accommodation that they be able to use medical marijuana while they're at work, and their doctor says, yeah, that would help them perform the essential functions of their job, and it wouldn't pose a safety risk to them. Okay, well, we're in Tennessee, so what would you do? So in states where medical marijuana is legal, you would maybe test them under state law. So in some states, employers are required to accommodate the use of medical marijuana. So obviously in Tennessee, you would not have to accommodate that, but in some states you would it's considered a medical condition. That's a legitimate, valid medical treatment for it. And so you'll go through this interactive process and you'll weigh whether you can have employees, under the influence of marijuana at work and have the healthcare provider weigh in. But in some states, even where medical marijuana is legal under state law, no accommodation is required. And so I've seen this with like positions where someone's supposed to be driving a truck around. A lot of times there are exceptions where states say, okay, employers, we understand, like even if employees are using medical marijuana, this is a safety sensitive position. You don't have to accommodate that. So again, this is state by state, locality by locality. So just make sure that you understand where this employee is located and what the law is there. In states where medical marijuana is not legal, you do not have to accommodate them. So that would be in Tennessee. And then just this little warning at the bottom, if you're a multi-state employer, just make sure you know what jurisdiction you're in. Okay, so there's been some case law actually supporting medical marijuana use as a reasonable accommodation. The Massachusetts Supreme Court allows employees to sue for disability discrimination under state law if they are fired because of medical marijuana use. So in this case from 2017, an employee was lawfully using medical marijuana to treat her Crohn's disease, and she was terminated after testing positive for marijuana on a drug test. And the court basically said that she could file a discrimination lawsuit saying that employers have a duty after an employee tests positive for marijuana to engage in the interactive process that we talked about to determine if their use of medical marijuana poses a risk to the health and safety of others and if a reasonable accommodation is available. So just consider it like any other medical condition and consider the treatment like any other treatment, and then do the analysis from that standpoint. All right, must I accommodate my employees' use of recreational marijuana in states where recreational use is legal? No, unless the employee works in Maine. So Maine is the only state that protects an employee's off-duty use of recreational marijuana. So basically, like if an employee is coming back from a trip to Colorado and they use medical marijuana or use recreational marijuana there, they come back to Tennessee and they test positive on a drug test, and you have a policy where you fire employees that test positive for marijuana. But they say, well, I was using it legally in Colorado where it's, you know, legal recreationally. Well, they don't have that protection. They don't have a protected right. In Maine, it's different, but basically everywhere else it's not. Most states have legalized the use of recreational marijuana, but they expressly state that they do not inhibit an employer's ability to discipline an employee for the use of recreational marijuana. That one's a little bit easier. Can you fire an employee who tests positive for marijuana after eating edibles containing marijuana on their Colorado vacation? Okay, I already answered this for you. Yes. There's no legal protection from being terminated for a positive drug test for marijuana, even if the employee legally consumed the marijuana in Colorado. Okay, so some practical tips. So what's the takeaway from all of these confusing and conflicting laws? So make sure you understand where your employees are located, understand your policies and if you need to update them. If you do have a drug testing policy and you are a multi-state employer, make sure that you've reviewed those policies. If your company receives federal funds, you can't allow medical marijuana, so make sure that you're consulting with an attorney if you're like a federal contractor, to figure out what you need to do and to figure out, you know, where there's a conflict in law, what you should do. Probably go with federal law. You'll want to train managers and supervisors and HR employees on discipline and termination of employees for using medical marijuana in states where medical marijuana is legal. So it's one thing to have a really well-written, nuanced policy, but you want to make sure that supervisors understand, like, hey, and you know, your employee in the state's allowed to use medical marijuana. We've given them this accommodation, so they're now allowed to use it. Okay, this is my last slide. Excuse me. It feels kind of silly talking about anything other than the pandemic that we're currently in. And I know a lot of you have probably heard that there's been an expansion of the Family and Medical Leave Act that allows employees to take medical leave if they have tested positive for the coronavirus. The regular requirements of the FMLA for the coronavirus have been kind of waived a little bit, and the law is really tricky, but it's basically until December 31st of this year, there's this kind of special exception for employees that have tested positive for COVID-19 or one of their family members has, or if they can't come to work because, you know, they have children home from school because the school's closed due to the pandemic. So be aware that this law is out there, and that while it's similar to the FMLA, it's a little bit different, and we've seen a lot of employers now having employees requesting accommodations or requesting additional time off for COVID-19, and it's a little bit different. We could spend another hour talking about those laws, but I will say my firm has a lot of resources on our website with that, and we actually had two attorneys do a presentation on it, so there's a whole nother PowerPoint about this. But if you guys have questions about the law, or you have a specific employee who's requesting time off or an accommodation, make sure that you ask someone how the law applies, and you know, we're always happy to help advise on that. And that is the end of my PowerPoint, so I will go ahead and allow for some questions if any have come in.
Yeah, thank you, Emma. We've had 2 or 3 questions come in here. The first one, early on, you'd mentioned documenting verbal conversations. Is there a preferred method to do that? Word doc, email? What's the best way to do that?
I've seen it done in email, and I think that that's fine as long as you have sort of a good email retention policy. Really, documenting is for you. It's to help you, and so you'll want to do it in a way that you can find it and locate it. But email is fine. You could do it in a Word document and print it. I would put it in the employee's medical file. Make sure to keep that separated from their actual personnel file because that is some confidential information. But either is fine.
Okay. A lot of our members are in small medical practices that might have less than 50 employees. And then, you know, in other instances, all the employees report to the CEO or the administrator. Do you have any guidance for them around the FMLA stuff about how they should be handling those types of requests?
Yeah, so if you have less than 50 employees, the FMLA doesn't apply. But certainly if you like report to the CEO and you're not sure, that would be something to raise with the higher ups at your company, just to make sure, because we even have employers who are like, we only have 12 employees in Memphis, but then they have, you know, 48 in West Memphis, and that actually covers them under the FMLA. So make sure that you are actually not covered. The ADA covers employers, I believe it's with 15 or more employees, so it usually covers smaller employers. So, you know, in terms of addressing it with them, I mean, if you're the one requesting an accommodation, I think it's fair to say, you know, I'm requesting this accommodation under the ADA. I'm happy to discuss this with you and have this conversation. Or if you have an employee requesting an accommodation and you're not sure if the law applies, I would definitely just reach out to an attorney and make sure. I don't know if that answers the question, but.
Yeah, I think so. You also brought up, I guess, social media investigation, for lack of a better term.
Yeah.
I think folks are requesting a little bit more detail on that. Are there things you need to be careful about? You know, obviously there's a, you know, do you accept someone as a friend on, you know, Facebook or whatever? That's one thing, but, you know, are there any do's and don'ts around social media?
Yeah, I mean, I would say as a manager or an employer, someone kind of hiring people or over other employees, I would avoid friending them on social media. If they friend you, that's fine. That's kind of them allowing you into that otherwise private sphere. Or if they have stuff publicly available that you can pull up and see, like they don't have a private, you know, Instagram account and you can see that, I mean, that's fair game. The don'ts are, you know, friending your subordinates or creating a fake profile to friend them and spy on them. But, you know, sometimes you might even get reports from coworkers like, hey, I'm friends with this person on Facebook and they posted this thing. If you get a report like that, I mean, that information was shared with you. But I just think the line is, if you're a superior, I wouldn't necessarily go friend your subordinates unless they friend you, and definitely don't try to kind of spy on them is what I would say. A lot of stuff is public on social media, so I don't know. I think people are getting a little bit smarter about it, but just kind of depends on the situation.
So if they are doing dumb things on social media and publicizing it, you can basically use that against them. It sounds terrible, but.
I mean, yeah, and like these stories have been in the news, but it'll be, you know, some employee of a big company posting something on Facebook that's offensive and their employer fires them and they think that they have a First Amendment right to post on their Facebook. Well, they don't. I mean, especially with a private employer, you know, whatever they're putting out there in the public world, you know, posting on Facebook or whatever, your employer, I mean, you can fire employees for that, whatever they're putting out there.
Gotcha.
Yeah.
Eric, if you can come back, that's all the questions I've seen.
Okay. Well, Emma, thank you so much for today and sharing a lot of good information with us. I've made some notes myself, and hopefully you'll send us your presentation so that we can put that on our website.
Sure.
And we are recording this, so this will be also available. But again, appreciate everyone's attendance today, and we look forward to our next meeting on July the 16th. And everyone be safe and stay well. Thank you.
Thanks, Emma.
Thank you. Thanks.